Okay, good afternoon, ladies and gentlemen. Thank you to join me for 11th week of this lecture. Quite actually through the days, a little nervous that I caught a cold. Actually, very infectious. Please take care to get you healthy through the weeks remaining for the winter vacation. Okay. We now that we have completed kind of our assignment of term, and you will now have time to wait for your grade in final project, and I consider your viewpoint is very possessive and quite explicatory about the issues. And many students did very well about that. Excellent. Especially your case brief is excellent, very well structured and finely matched to the usual format the lawyers and attorneys that employ to respond with this responsibility. And also the death penalty has been well articulated about the series and gist of rules what actually held over the decades in adjudication. You see, your beginning point is Foreman versus Georgia, and what actually a very revolutionary basis has been laid about federal context of supervision, the imposition of death penalty, and the kind of statutes, death penalty statutes is actually paradigmatic, since the criminal justice system generally depends on the state choice and preference, and now 2.5 of the United States abolished the death penalty in their state criminal justice system, and Massachusetts in the mid of 1980s and others. The beginning point to be questioned by federal authority as the constitutional ground, the 8th and 14th Amendment actually proscribes the cruel, unusual, cruel punishment, and also the imposition of death penalty should be in comfort with the constitutional requirements, due process for all. The context has been lately dealt in many projects returned in your class hours, and I am very satisfied with your ideas and propositions and suggestions and the kind of descriptions about federal statute or international treaty, and thank you for your deep engagement on that point. So now we complete some basic assignment envisaged in the first day of this term, and the course class plan has been scheduled to meet the kind of progress that has been announced early days, and the process is generally completed in my view, and the remaining 2 or 3 weeks will be devoted to kind of some issues and classic notions and works that could unravel the behind thinking of common law lawyers and kind of a basic philosophy to be interactive in shaping the legal system of the United States and Great Britain, and also the kind of basic understanding of legal system. For example, Court of Chancery, what is court, and also what's the basic profile about antitrust laws in the United States. What is Sherman Act and what is that? And also, how do we conceive the types of killings in the criminal justice system of the United States and Great Britain? Actually, the scheme is very specific and in spectrum to making a distinction in pattern of engagement or mental state on others, very instructive through the first and second degree murders and what is common law crime and a kind of manslaughter. You will also introduce the notion of homicide, murder, kill, and what is the element, criminal element that is expected in statute. The common law crimes has been developed in the courtroom, and often the state criminal system has enacted the statute that would endorse the kind of theory and also the elements established and found through the court process, which also is incorporated into respective provisions and clauses. So, for example, you will see same element in burglary crime or robbery, armed robbery, and felony murder, the kind of crimes oftentimes shared over respective jurisdictions and virtually not variegated over many important elements and profiles of crime and kind of prerequisite for punishment. So, what actually often the state authority use the catch-up price to incorporate the common law crimes, which is not spelled out in any express terms. So impliedly, all the court rules of history dealing with the criminal questions and kind of crimes would survive without any express terms or provisions. That is usual practice. It could be ascertained through the state jurisdiction. So my plan in this week is to explore some exciting event. What actually Professor Bohanian has been excellent about is presentation in the international symposium. In the last week, I've introduced some local conference in held in collaboration with the local prosecuting offices. Tomorrow, the law department of Joseon University will hold an international symposium. The theme is the recent development of a criminal law and theory across the jurisdictions. So Japanese and Chinese scholars will participate to present their insights and views about the national laws and local regulations. And Professor Kang Hyuk-shin would assume the role to translate for the Japanese scholar, and I was asked to take a role of translation for the case of Professor Bolani. So I had a chance to read this article. Very expositive. That what make his point in very persuasive cultural defense in the United States. So I will suggest some sharing in the first part of this class about this topic. I prepared some PowerPoint presentation as you are available in production. A cultural defense in the United States, and the thesis was structured in 5 parts: introduction, cultural defense in theory, and he made a good argument over typical cases, which is quite unusual. Perhaps some enclaves about Laotian immigrant and Chinese immigrant, and kind of a distinct group in the United States may perpetrate the kind of crime, but in under the influence of a dominant culture in his or case. So that is to be a cultural defense to strengthen their claims. Of course, you will see that the traditional affirmative defense could be bolstered from the assertion of distinct culture or any affectation or their intellectual or cognitive understanding, and propensity is due to be shaped in that influence and understanding. Then might be raised as a cultural defense. However, how do you perceive, for example, the maxim, the subject is due to respect the law of lands? Actually one constituent for the community that they need to pay due attention and respect. Consider the contrary structure in the operation of law. They would enjoy the prestige or status in the land because of a very assistance with law. And law is an instrument to provide a shield for security or personal safety, and also could be a source, ground to sustain the welfare benefit to others. So they could seek advantage from the law of land. The opposite aspect in that sense is to respect the law they reside in. And temporary residence is also okay. That should be respected. That is basic concept we share in perspective, the dominant perspective. And Professor Bolani also made that aspect in his final message in his article. I consider it very powerful and persuasive through the diversity in disagreement and contention. Very helpful. You see, the criminal law is generally possessed of a ubiquitous nature of response. Often we can be ready to identify any kind of culpability of scope of human conduct and activities. So murder, burglary, theft, very evil, and the kind of activity that brings a social harm to deprave the community. Actually, we have a general understandings, notwithstanding the culture and types of what actually nations. So often reasonableness standard could well operate to make uniform in shaping crimes and misdemeanors. Ethical code can be in convergence vastly of jurisdictions. But the kind of a comprehension is quite adequate. So how would you find the leniency that could be complemented with cultural defense? Nonetheless, we still see the kind of corner of a twilight zone between the cultural majority and distinct group of culture. So, let's consider, for example, Oyaku Shinju in People vs. Kimura. Oyaku Shinju has a root basis from Japanese word and a custom of history and sustained in wear spirit of housewives. So the Japanese wives could commit suicide and take any other last action to kill her child wives. In this case, Kimura has taken a long ride in the beach of California, Santa Monica, kind of Hollywood. He took his two babies, one boy and one girl, 2 or 4 years respectively, and he took his babies into baby stroller and left it in the bus, and he took the baby and took work into a Dipsy. What is his reaction? That meaning that she intends to drown himself and his 2 babies' deaths. That is, of course, from severe emotional distress incurred by her husband, adultery, and kind of quandary to break his family relations. So that actually a shocking incident led her to decide on suicide and kind of killing over his her 2 babies. And of course she was accused of 2 counts of suicide and first-degree murder. And in the process, the citizen of Los Angeles, principally from the origin of Japan, claimed to apply the Japanese practice and consider the case in the criterion of a Japanese custom, and also what factors from the practice should be taken as granted to decide the criminal penalty or in finding an innocence to the interest of defendant. Kind of background has been detailed in your printout, and that could be received by judge, meaning the case is very selective to be successful by cultural defense. As you read through the article, the mainstream of criminal jurisprudence in the United States generally defines cultural defense as independent. It is a little factor to be considered when they take the process to weigh the merit of affirmative justice, affirmative defense. So the how to operate to mitigate the sentence or prove his innocence is very weak if he stresses cultural defense. So not to be received in chances not considered to be received as effective independent defense. So you consider the case is highly occasional. Take it first case, People vs. Chan. This case involved newly immigrated Chinese named Chan, and he actually cruelly killed his wife, committed adultery, and adulterous relations was kind of factor to what I call kind of provocation or heat of passion. So you see the criminal theory about second-degree murder. So that was dealt actually on the basic criminal law theory. You see, then there would be a little room that Chan could be successful to argue for his innocence if he relies on a Chinese culture or custom. Many evidence were produced to prove kind of promoting sensibility and general recognition about a reaction from husband in the kind of a situation. So could be argued from that viewpoint. However, the court would not prefer to take the kind of defense in any determinative consequence. So you consider the success of cultural defense would often mitigate the kind of crime to the lesser crime. So second-degree murder could be reshaped with for manslaughter. What is manslaughter? It is a lesser crime of murder case that could create many chances of probation or a 2 or 5 year sentence actually. So very helpful, you see. And basically you will be required to approach the cultural defense could have a historical basis. What is nulla pena sine lege? In the Latin word, there is no penalty without law. So ignorance of law would often exonerate in this perspective. And also you will understand the 4 types of specific rules or principles which ramifies from this principle. So nulla pone gene previously said, or nulla pone gene cert, or kind of. There is no penalty without a law of certainty. The legal certainty is important, especially in the criminal province of law, since the criminals have to chance to take a precaution. So ex post facto laws would be private as a theory and principle. And also what nulla pone gene lege scripta, very what actually consequential, especially in the civil law tradition. So there is no penalty without written law. And what is the last one? Nulla pene pone gene lege stricta. There is to be no penalty without civil law. So the rule of lenity is accepted in the general criminal law theory. So if ambiguities arise, the solution should be based on the side to the interest of a criminal. So strict interpretation is basic way to approach what actually proscribing some arbitrary use of criminal provision should be understood, or strict understanding of terms and phrases. Elements of crime should be evidenced on what a higher extent of production of evidence. So beyond what is the meaning that could be ascertained in the rule beyond reasonable doubt. So mere preponderance evidence is insufficient to make a convicted culpable. So the Professor Bohanian begins his discussion with ignorance of law. Generally, ignorance of law does not exonerate the suspect or criminals. The law is applied objectively, and the common law judges would not take any sensitive investigation into the nature of a criminal mind about their apprehension or comprehension. The law is actually has implications as is. And his point is, however, subtle about a mistake of law. In other angle, the mistake of law is one justification in the common law or criminal theory, which is a little distinctive from ignorance of law. In some cases, a mistake of law may operate as a mitigating factor, or in other cases would constitute the requirements about crime elements. So should be proven beyond reasonable doubt to incriminate the criminals. So the kind of notion has been briefed to develop his theme about cultural defense in the United States in theory. What the proponents of cultural defense include multiculturalists who asserted in an increasingly pluralistic society, fairness requires that the criminal justice system be individualized to moderate the strict application of the law, and others who oppose multiculturalism in general support the admission of cultural evidence on due process grounds. His theoretical source is very explicative and very authoritative by illustrating many scholars. For example, Dorocville is a legal anthropologist, and his theory is termed the interest convergence theory. Upon the real success of cultural defense, the judges or jurists may share to be sensitive about cultural defense. They could have some personal experience about the aspect of culture raised in criminal defense by defendant. Then they could be mindful to listen to the cultural defense. And culture in that dimension would be exchanged among other between jurists and the criminals. Then the probability to be successful of cultural defense would increase generally. The interest convergence theory. Actually, the problem is quite structural, which means the substantive and divisive line is not clear. So we have many elements to be agreeable among the various legal systems. The Professor Bohemian has illustrated Korean Criminal Code, Article 6, which originated from German authority, have same provisions in regulation of crime, and structural similarity, of course, very expectable, you see. So traditionally, ignorance of law or doctrine has not been accepted by Germany, making the German legal system distinctive from common law. The prescription is facially contradictory with the general theory of ignorance of law. Nonetheless, that could not end the discussion and any contention involved with this topic. So we can eventually find many tools and vehicles to make them share and actually consonant among another. So just structure to make them disagreeable, but could have many spaces to be convergent and agreeable, producing any plausible solution eventually. So the cultural defense take his argument in the first place that cultural defense is kind of factor about traditional affirmative defense. That argument would be actually acceptable in our sensibility and recognition, and also so his conclusion will suggest a very important aspect of this contention. He considered the need for deterrence. Deterrence is one objective we pursue in maintaining a criminal justice system, as you know. And consider, for example, an independent cultural defense undermines the doctrine of equality. This view is held by general people of the United States, and also perhaps will take a large support of scholars and academia. So consider the group of a distinct culture. The group would actually the stage the crime would occur. And in that case, we'll see the discrete view among the group family members and others about their exposure to dominant culture and actually some differences individually among the group of members. Then we need to appreciate the doctrine of equality to be upheld through many contexts of their interaction. So the crime is one event which is actually very bad, often condemned by community people. And of course that is very aspect the criminal law and justice system would operate. And also consider equality concern among various stakeholders, interest holders, and between the victims and crimes. So cultural defense could be a factor that the judge should appreciate of adjudication and a determination of a proper adequate sentence. However, cultural defense in Bohemian's viewpoint need not be independent, as stressed. And his final point of conclusion is the standard criminal law defenses are adequate to ensure consideration of cultural factors. So in his conclusion, we find the kind of important instruction to articulate the genuine nature of this discussion. Under current American law, culture has been used to negate an element of the offense, such as mistake of fact concerning consent in rape, as in the Montgomery by capture matter, and to support the notion if main sexual assault statute shall require the purpose of sexual arousal as an element of charge instead of purposeful mouth-genital contact, Carga would have lacked the purpose. In addition to the flexibility provided by prosecutorial discretion, the so-called de minimis provision. So, very insightful to have a comparative comparison between Korea and United States. You see another helpful case to unravel the genuine feature of this issue. we can see some distinct culture from Afghanistan custom. The case name is titled State First Karga. In this case, sorry, a call from Professor Kim Jong-un, perhaps a call to report for dinner. We have I saw actually we'll host a dinner party for the invited professors, international symposium. And Afghanistan custom actually endorse the kind of a contact, a parental contact to the genital organ of a minor child. Actually, that is one way to express sexual sacred gratification about growth, and the kind of way to show affection between parents and children. In this case, Karga was a recent immigrant from Afghanistan. Actually, he could be classed as a refugee, status of refugee in terms of a international treaty, a kind of persecution, and he actually was led to settle in the state of Maine. The state of Maine is the kind of a sexual assault statute, and in the meantime, Karga had occasion of babysitting of a child from his neighborhood, and his activity was aroused the suspect from the parent of neighborhood child. He showed the picture depicting his kiss on genital organ of a child. That has been passed up by the parents. In the day of event, the Karga's activity was witnessed by a child who kissed the sexual organ of a 18 child. So the child reported that incident to his parents, and actually the parents in this case decided to report the incident to child. So Karga was pursued in search warrant, and also somewhat actually with the aid of a social worker and translators. His house was actually searched to collect the evidence and others. Actually, he was prosecuted on the basis of a main sexual assault statute. The progress on this kind of a case is virtually similar over many distant global cultural difference. The immigrant from Afghanistan would petition to apply the Afghanistan custom, and sought favor from the court in the interest of Karga. So the kind of activity is not actually bad or unacceptable. It is one way to be practiced oftentimes and generally over the cities. It is one communal ceremony between parents and child. the Islam law would prosecute kind of sexual relations between parents and child to death. But that is not a sexual kind of activities or behavior. Should be deemed respectable, or actually kind of a sacred interaction between child and parent. So very conspicuous and actually most distinguishable from other cases, that the custom is quite stark and impressive. Let's take another case. People versus More. It deals with the Hmong immigrant. Mao is an immigrant from Laos and now studies in United States, and he took his tribal female to his college dormitory, and actually applied some undue influence or even forced to have a sexual intercourse with the kidnapped female. His defense is that Laos has the kind of a custom. What does it mean? It is the word from Laos. Actually marriage ceremony through capture, and his creation of kidnapping is actually fabulous and in some sense fabricated to test the virtue of a lady. So he would be a villain to oppress the female for his personal satisfaction, wishful engagement to actually fake for a sexual intercourse. Then women would resist. I'm not ready. I'm a virtuous woman. The kind of that would be preceding their official ceremony of marriage. It's one custom alleged by defendant. In that case, the cultural defense could realize some success in his criminal defense. And, he received the right penalty in consideration of rape crime. In the process, the victim would admit that he was actually raped. A forceful surrender to the perpetrator. But the sentence is 120 days imprisonment, jail, very light, and also was fined with a $3,000, not great amount in my general sense, and 90% was paid to compensate for the victim. So how do you assess this kind of response from the court? Actually, in successful cases, the court would render a light penalty and often be assigned with the probation or measure of probation, or the actual imprisonment would be waived in some cases, and the penalty would be lessened to manslaughter. Often the beginning is about the second-degree murder. The case would be rape or murder, in heat of passion, and heat of passion will be prescribed as second-degree murder, often and generally of jurisdictions. Manslaughter is less crime, you consider, and the intent or other mental state required as of a criminal theory is not specific, and also recklessness or general fault nature. Non-negligent civility is little gross than negligent killing, but not intent crime in understanding. Hence, it is lighter than normal kind of murder crime, first degree murder or second degree murder. And what others? You consider, for example, doctrine of equality to be complemented more in aspect. You need to have some need to appreciate between new immigrants and settled context of same culture or origin. And so long years in residence about Asians or others would be made distinct from new immigrants from same country. You are Chinese origin, but immigrated last year. I'm more experienced in this culture. Then how do you assess any difference between two groups? And one other aspect, so many, actually multifaceted to be individualized and specific. So specific the case approach is very commendable in my appreciation. So that also would be agreeable with the view of Professor Bohemian. So in cultural defense lacks due quality, ethical quality as an independent basis of defense. And multiculturalism is the kind of ideal we now pursue in Korea also. We have many foreign workers now contributing to the national economy. Their cooperation and also participation in the community would well be helpful, I suppose. And multiculturalism is one slogan to create the kind of success in the United States. The mixed nature of country with diverse ethnicities, races, and black and white people, now Hispanic immigrants and Asian people increased. The kind of concept to promote the progress of society is especially emphasized in the workplace, the equal right to work. And Professor Bohemian, of course, supposed the kind of approach in many personal affiliations. Nonetheless, his message echoing that the cultural defense is a distinct issue, especially when we consider the criminal consequence. So through his article, we find many famous names, or Professor Chu, and sincerely from the law school of George Washington University, and Derek Bear is one legal anthropologist, and their view is quite eclectic to incorporate the idea of multiculturalism. So, for example, you see in the part of conclusion, proponents of cultural defense argue that the right to introduce subjective criminal evidence in a criminal trial is not only a liberty right, but also a cultural right protected by Clause 27 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, which mandate the protection of the right of minorities to enjoy their culture. Accordingly, Professor Chu has offered the following language for new cultural justification defense. The defendant is not guilty of an offense if a reasonable person of a similar cultural background to the defendant believes that the harm caused by the conduct of the defendant was outweighed by some other imminent harm prevented by the same conduct. The defendant cannot claim this defense if there was a way other than the conduct to prevent the harm sought to be avoided. So the cultural defense could only be successful when the defendant would be less eligible to rely on the kind of specific activities. His cultural and only justification could be made on that basis, and no way to avoid this consequence. The kind of absolutism would effect. However, that is also a point to be feared of in general theory of a criminal law. And also the balancing perspective would do good to appreciate the consequence in due context. It is the harm caused by conduct of defendant, and also some other imminent harm prevented by the same conduct. While the international covenants, so I actually very bad on my body, severe cold. I'll drop by a drugstore nearby after this class. Professor Chu's proposal, obviously well-intentioned and carefully conceived, problems of subjectivity about when proposed cultural rights conflict with other rights at the state level. So reasonableness element is very embedded through the history and the kind of people to found the legal system in region and what actually history. So how do we moderate the kind of competing quest to be resolved in any context? The majority culture will certainly be a source to authorize the criminal sanction analysis. So it is political in that sense and need to be sustained in dominant aspect and of course corroborated with the argument of Professor Bohemian. So the minority culture need to be actually congruent and to in cases of controversy, the legislators would employ many ways. In some cases, they would keep stance away from enacting the statute. If the minority culture is very strong in explaining their communal ethos or the share of minority cultural people would be large, relatively large, of course not dominant. In that case, it needs to be scrupulous to create any statute in strong demand against the minority culture. That is one way. And other alternatives to resolve the controversy in milder fashion. Nonetheless, it is of course true, as Professor Wayne argued, that the lower land has to be respected. That serves many purposes, long believed to be indispensable in maintaining a criminal justice system. And one other part about his argument is model penal code, de minimis statute. And that de minimis statute was imported by the authority of a main state. And the model penal code actually seldom used, not preferred by legislators or others, but dynamic and innovative provision that would mandate that the judge dismiss a prosecution if, having regard to the nature of conduct charged and the nature of attendant circumstances, it finds that the defendant's conduct. The three items were incorporated into the minimis statute. Please pay a focus on item third. Third exception now be read in this. It presents such other extenuations that cannot reasonably be regarded as emphasized by the legislature in forbidding the offense. The court shall not dismiss a prosecution under subsection 3 of this section without filing a written statement of its reasons. So, on the basis of this third exception, the judge and jurist would exercise an ample choice and plenary discretion in determining whether the act is culpable or punishable. So the legislature would leave circuitry for the aftermath deliberation of judges and jurists. So as Professor Webster commented, he served as a member of American Law Institute and authoritative to develop the theory of criminal law in the United States, one great authority in this area of law. And he commented on the quality of this exemption. Now, I'll say a word of general jurisdiction for this section 2.212. Nothing is more common in criminal law enforcement, of course, than the exercise on the part of prosecuting attorney. To some extent, grand juries, where there are grand juries of kind of unarticulated authority to mitigate the general provisions of the criminal law to prevent absurd applications, and this is an in-camera operation. It doesn't come to court. It has been general purpose of court to try to lay a foundation for bringing this general practice in criminal law administration, which we agree is necessary, somehow further out into the open. And the only way to do that seems to be to vest in the court a kind of power analogous to the general dispensing power. What is general dispensing power? So from this inscription, you will see the ways of judicial deliberation as analogous to the legislature. So the judges could create to fill the vacuum in very ample power and authority, which is now exercised in practice by the organs of administration. Professor Wexler's characterization of judges' role under section 2.12 as being analogous to prosecutorial discretion that is brought out into the open by the court is unduly restrictive, since sections begins with the court shall dismiss a prosecution if, rather than the court may dismiss. So it is mandatory that the court dismiss a prosecution if blah blah blah. So the delegation has also strengthened this term. The scope of delegation is exemplary, very extent of leniency, which well comparable with the ways of legislation. And also the court is mandated to dismiss the prosecution. That is a distinct way oftentimes would not be available in the criminal deliberation. The court and also according to the professor's viewpoint, the title of this section is not adequate. It is diminished statute, but actually the first and second section is general of criminal laws and others, so could not be viewed sorry, the third is distinct to be relevant of this title, diminished. Only the first and second section deserves this title, diminished. So consider the quality of a third section, and now we have first and second section. First is read in this. It was written was within a customer license of tolerance, neither expressly negative by the person whose interest was infringed, nor inconsistent with the purpose of the law defining the offense. The second, did not actually cause or threaten the harm or evil sought to be prevented by the law defining the offense, or did so only an extent too trivial to warrant the condemnation of conviction. But the third exception would be different. And in Karga, the state court would refer to the precedent on the diminished statute, which is original in Hawaii and New Jersey, and opine as described on page 9. Consider, for example, plenty of elements would be a factor that need to be considered by a court. For example, the background, experience, and character of defendant, which may indicate whether he knew or ought to have known of the illegality. The knowledge of defendant of the consequences to be incurred upon a violation of the statute, the circumstances concerning the offense, the resulting harm or evil, if any, caused or threatened by the infraction, the probable impact of the violation upon the community, the seriousness of the infraction in terms of punishment, bearing in mind the punishment can be suspended, and others. So many factors were illustrated by the court. And in Karga, there would be a scope of expert testimony about culture and custom in Afghanistan. For example, University of Regional Center for Near Eastern Studies, and another from a religious teacher corroborating the cultural defense. was presented as evidence in the form of statement. So actually, the court convicted Carter of 2 counts of gross sexual assault, while sympathetically suspending his sentence. On appeal, that is the rendition of judgment by the lower court. It was appealed, and Supreme Judicial Court may deal with the question and was overruled. The appellate court found the trial court was erroneous that failed to consider all of these relevant factors. The focus is not on whether the conduct falls within the reach of statute criminalized. The court also took a look into the rest of history. Actually, in the original provision, the conduct could be exempted if it was for the purpose of sexual gratification, what caused bodily injury or offensive physical contact out of a legitimate concern, for excluding innocent contacts, such as for proper medical purposes or other valid reasons. So, the purpose of sexual gratification has been present in the original code. However, later the element was eliminated. The sexual gratification requirement was removed, which creates the basis the Carter was convicted. This context will reveal that the prosecution that opposes challenges and also has some implications to dispose this case. In reviewing the differences between American cultural norms and the Afghanistan customs, the court also make a point to be insightful, consider, and his action of kissing his son's genital clearly criminal under the statute, but the circumstances of the conduct and the circumstances of defendant call for leniency. The trial court has suspended his sentence, which is generous, but there is also incur a severe disadvantage in view of a Professor Bohemian, since he would have a criminal record and the obligation to register under the sexual offender registry program. So many public programs to administer precaution against the sexual criminals, offenders, and the criminals who have prior criminal history record about sex offenses, and he's an immigrant, so he could also have possibly face deportation. So the sentence of suspension could be advantageous on one hand, and could be devastating in some cases, since he is on a very distinctive status as an immigrant. So how do you assess how do you assess this outcome ultimately, if it is successful or not, when you consider the operation of cultural defense? Generally, cultural defense would be difficult to receive. That is a dominant practice, as I introduced earlier in the United States. And you now have a selective case to claim success, generally successful, but not complete to satisfy the claim. So Professor Sinceri has borrowed from Derek Bell's interest convergence theory to explain the success or failure of these cultural defense claims are proportional to the similarities between the cultural motivations of defendants and the cultural interests and views of the majority culture. And you will have a similar case in State versus Apollos. It deals with a Laotian immigrant, and he stabbed his wife to death in a jealous rage after she received a phone call from a former boyfriend. And you now recall on Chan's case, who is a Chinese immigrant. So cultural defense offered to rebut an element of the offense charge, and in some cases to bolster traditional formative defense, and that could be adequate. No further that be elevated into any independent measure. So cultural defense often could not be shared on what the kind of fair extent of extensive deliberation could be a component to be complemented with other factors into final assessment by the judges about formative defense. And Professor Bohemian also made a point concerning Article 13 of Criminal Code. When a person commits a crime not knowing that his act constitutes a crime under existing acts and subordinate statute, his mistake of law is defense, provided the misunderstanding is based upon reasonable grounds. So often the subjective aspect, subjectivity, would be claimed, and subjective aspect is claimed, but the problem very lies on that aspect. The subjectivity is not friendly with a criminal justice system. It is required to be objective and indiscriminate in application or this. Nonetheless, reasonableness is also another alternative burden to strengthen the argument of cultural defense. So we need to take an in-depth inquiry into the mental state of individuals. Actually, the criminal law emphatically stresses the individualistic attribute and exposure in criminal engagement. So death penalty is one illustration I could make of actually we may defy the organized crimes collectively to satisfy specific crime. So the engagement might be minor, about waiting to kill the victims or others. They would share a plot to commit a robbery. That would be one fact you expect in the death penalty cases. The criminal theory may be dissociated with sentencing deliberation. We need to take a look into an individual, his specific activity, whether to determining whether to merit the death penalty or not. How is individual activity or engagement is culpable, although they will collectively be punished as armed robbery or forced murder. And a mistake of law has been spelled out in this article. It does not refer to simple ignorance of the law, but purpose not to punish a person when he knows that his act constitutes a crime under general circumstances, but misunderstands that in a specific case it does not constitute a crime because it is permitted by laws and regulations, and such misunderstanding has a justifiable reason. Article 16 of Korea's criminal code is not inconsistent with the legal effect of common law maxim that ignorance of the law is not an excuse, since blah blah blah. So you will take an explanation to make a convergence between two legal systems. Structurally, it could be made distinct, and his view is that the German law is another variation from common law. Well, actually, to be departed structurally from common law theory. But his point is so welcome that the substantiation would enable us to find their common sensibility about the issue. Germany is the state that the mistake law of law does not negate mens rea, but is a separate defense. So mistake law of law is seriously considered and independently as a separate defense. That would not well, actually compatible with common law theory. Consider the part of his version to argue on the differences and similarities between two legal systems. So he evinces his theme very persuasively and in coherent presentation about point of contention and what disagreements among the scholars, and he contrasted differing views from scholars of authority. What actually illuminated in organized fashion to expose us to an interesting journey between two criminal justice. Ignorantia legis non excuse. The doctrine is applied both to foreigners as it does to the native born. As Daniel Webster expressed, every foreigner born residing in a country owes to that country allegiance and obedience to its law, so long as it remains as a duty upon him by the mere fact of his residence and the temporary protection which he enjoys, and is as much bound to obey its laws and a native subject or citizens. So deterrence, retribution, and prevention and education, the kind of objectives and ideas that should in the criminal justice system will require the law objective, and also the point to be shared about communal security and personal safety and protection of property rights. So cultural defense in that structure of thought or substantive elements in operation of law is actually making the status of cultural defense meager and slim. So take the examples which are considered very successful about cultural defense claim, and exercise to understand the gist of reasoning, what actually would help to delineate the theory on cultural defense in the United States. So, who are proponents? For example, Allison Dundas Renstrom, a person who is culturally motivated to commit a crime, is less blameless than another who is not, and the difference should be officially acknowledged by a rule that will allow for culture to serve as a partial excuse resulting in mitigation in the proper circumstances. How do you agree with the view from Allison Dundas Renstrom? And Alan Chu, who is a professor of Yale Law School, also will be one a proponent about cultural defense. He would go further, calling for the cultural defense to serve not as an excuse, but as justification to exonerate the defendant in the proper circumstances, reasoning that a partial excuse defense gives the false impression the defendant's natural tendency to comply with the cultural norms is somehow an indication of their mental or emotional instability. In People vs. Chen, the murder charge was reduced to the lesser charge of manslaughter, and the defendant received 5 years of probation for his crime. So you also have some remark about tolerance. Tolerance is one element of modern citizen. Tolerance in French pronunciation. Actually, one element expected about modern citizenship. Dolan Kalama, a strong opponent of cultural defense, has articulated the equal protection argument as follows. Often the scholars in opposite view would raise an equal protection of law doctrine. Tolerance of the use of immigrant cultural evidence in criminal proceedings fundamentally conflicts with the principle that the protections given by the laws of the United States shall be equal in respect to life and liberty. For all reasons, indeed, permitting cultural evidence to be dispositive in criminal cases violates both fundamental principle that society has a right to government protection against crime, and the equal protection doctrine that holds that whatever protections are provided by government must be provided to all equally without regard to race, gender, or national origin. So in this case, tolerance would not be a virtue. They should be cautious about this use by jurors or jurists. So how do you perceive between tolerance version presented by Donald Coleman and interest convergence theory purported by another scholar, Derek Bell? This morning, Professor Jongbin Kim, who is distinguished professor in this department, who also served as chief prosecution officer in the nation in early millennium year, presented a very interesting story with his colloquium to be convened by concerned professors and students. Very exciting to listen to his presentation. And he pointed to many index of nation, which indicates that Korea is a very advanced country, and his recognition is expensive to create a more advanced nation. And he raised tolerance as one of elements that the modern citizen has to make himself equipped with, and also practice to bear common benefit for the community. One element, and this is professional dimension, but could make us reflexive. And what other point to be found in any significance about understanding of this area of law, modern okay, I suppose it will be all for this class. I hopefully expect that you join the International Symposium tomorrow and entertain such precious opportunity to share viewpoints about criminal law, and also the kind of a trend to be charted to complement your general understanding of criminal law. That I consider that would be very valuable. I encourage you to participate and hopefully see you. And also you will be given a chance to raise a question about your point of concern. Thank you for your attention. I'll see you in the next session.